Welcome to Talking Foreign Policy. I'm your host, Michael Scharf, the Dean of Case Western Reserve University School of Law. In this broadcast, our expert panelists will be discussing corporate liability for human rights abuses. For our program today, we've assembled a panel of leading human rights experts from the United States and Europe. We'll begin with a one-on-one conversation with Thomas Buergenthal, the youngest survivor of the Auschwitz death camp, who went on to become the Dean of American University Law School, to serve for 12 years as a judge on the Inter-American Court of Human Rights, and then another 10 years as the U.S. judge on the World Court. Thanks, Judge, for being with us today.
It's a great pleasure.
So let's start. In 2007, you published A Lucky Child, a memoir of surviving Auschwitz as a young boy. How did that experience shape the rest of your life and especially your work in the human rights field?
Well, I suppose I would not have written about human rights if I had not been in the camps. It also shaped me in terms of a need to write about it and to contribute in one way or another to a situation where we can prevent the things that happened to me and that are still happening to a lot of people in the world.
You were just mentioning before we came on the show that you are currently working on a report about the North Korean concentration camps, and I hadn't heard anything about that. Do you want to tell us a little bit about that project?
Well, it's a project about, as you mentioned, about the work camp, what they call work camps, but in fact they are worse than concentration camps. I thought I knew everything about concentration camps and how bad things can be in it. I must say, what I heard, if it is true, and I have no reason to assume that it's not true, this is much worse than anything I have experienced.
And
that happened.
That's hard to believe because
Yes.
I think many people know about what you went through at Auschwitz.
Yeah.
And North Korea is worse.
No, this is, for example, something they would arrest one person, and then because he was guilty of something that they say was guilty of, they would take the entire family with them, one way. They had methods of cruelty in terms of getting rid of babies that were impregnated by the guards. Methods that I must say I'd never heard of what you can do when it would be just as easy to kill the baby, which was supposedly just the utter cruelty and inhuman cruelty that to me was something I'd never heard of. So if all of this is true, it is the worst, I think, that the world has ever heard of, these what's happening in these camps.
And this is from somebody who not only lived through that, but you were a judge in so many human rights cases and also human rights cases that came before the World Court. Let me ask you about one of the cases you presided over when you were at the Inter-American Court of Human Rights, which you ended up being the president of. This was the case about whether the Honduran government had to pay compensation to families of victims of forced disappearances that had occurred during the 1980s. Many people say that was the most important of the Inter-American Court's cases. What was the significance of that precedent?
Well, for one thing, it was really the first really important case to reach us. And secondly, there had been no decisions in international courts about international law and disappearances. So we really had to deal with the subject and come up with a theory in which we could deal with that terrible, these cruelties.
And part of that case was that the government was responsible for prosecuting the people, and they couldn't give amnesty to the individuals who were involved, right? So if the U.S.
Let me just interrupt you, because what was interesting particularly in this case was that the government would say, well, this person hasn't disappeared if he went to his girlfriend. But the problem was, how do we prove that the government is responsible for a disappearance when everything was done to keep it secret?
Right.
And so to develop the theory in these cases was set precedents for many others that are now happening in many parts of the world.
But the idea that governments are, after these things come to light, responsible for making sure that there are remedies to the individuals is one of the biggest things that came out of that line of cases. If the U.S. Supreme Court decides that corporations cannot be sued for human rights abuses that they commit abroad, would that violate the spirit of the line of cases we were discussing?
Very much so. Very much. I mean, the whole idea that corporations somehow are exempt or immune and can only be tried in their own countries under certain circumstances, and even not that, that's not international law.
So then let's take your career forward to the International Court of Justice, where you served for 10 years. This is the court that is in The Hague. It's known as the World Court. It's the court that hears cases between countries. While you were there, it's pretty rare, I think, that a judge of that court will side against his own country. And there were several cases involving the United States that you sat on. And in two of those cases, you did decide that the U.S. was wrong. These are the cases that you held that the United States failed to advise foreigners of their consular rights in proceedings that resulted in death sentences, and that was a violation of international law. Did you feel at the time that it was risky to exercise that kind of independence to go against your own government?
No, and I should tell you that this question was asked even by my colleagues. And my reply was always, I'm sure I'm not going to end up in Siberia for proceeding the way I proceeded. It seemed to me, first of all, the U.S. put me there because they had confidence in me. And then that meant that they also had to take my interpretation the way I've felt it should be interpreted.
But that's rare. In other countries, many times that the individual judges don't feel that kind of security.
I suppose. Yeah. But I must say it was easy for me and I should tell you that nobody ever from the U.S. government even mentioned to me, which is interesting.
That's good. Yeah.
So I'm not a hero in that regard. I just felt I was free. And also it was important that somebody set the precedent that you can do that.
Yeah. Well, you were a little bit heroic in the eyes of many who followed your career, not only by standing up to the U.S. government from time to time as a judge, but also you weren't very shy about dissenting from the majority of other judges, and especially in cases involving human rights, which is really your bailiwick, your expertise. So I'm thinking about the Belgium arrest warrants case. There, the majority held that the foreign minister of the Congo was immune from suit for crimes against humanity. Why do you believe that was the wrong decision?
Well, because I think they were applying international law that maybe was valid 20, 30 years before the case was decided, but international law had changed. At that point, we already looked at the Rome Statute or the drafts of the Rome Statute, and people holding these positions were not immune anymore. So it seemed to me that it was a new world, a new international law that was needed. And if anybody can make those pronouncements, it's the International Court of Justice, and it should have done it. I was fortunate to be accompanied by two people whom I regard as great international lawyers, so it was easy.
Yeah. Now, unfortunately, they didn't follow your advice on that, and I think that did set back international law. Yeah. I noticed that in Africa, there is a new court of Africa criminal law being set up, and it will exempt the heads of state from responsibility. And so it seems like that, sometimes a case like that can propel international law forward or set it back. So
I should give you I shouldn't be saying that about the International Court, but I think the problem at that time in the International Court of Justice was that too many former diplomats sat on the court.
Instead of career judges?
In career judges or academics or human rights specialists, and that has an impact. And of course, they should be there, but it's very difficult to change their minds.
Even career judges can be political, and I think we see that especially at our Supreme Court. Later in the program, we're going to be discussing the U.S. Supreme Court's case of Jesner versus Arab Bank, which will decide whether corporations can be sued for human rights violations. If you, who are non-political and have had such a career in the human rights world, were sitting on that bench, how would you decide the case?
Oh, I would hold that corporations, like individuals, can be tried for violations of international law, particularly serious violations of international law.
And you think that's an easy case?
Well, it's not easy because two lower courts, or one lower court, held the other way.
Yeah. I mean, they basically said that international law only applies to states, not corporations.
I mean, that's another notion in the 21st century. To say that in itself shows a misunderstanding of what contemporary international law is all about.
You know, and even back after World War II, for the kinds of atrocities that were committed to you and the many people who didn't survive Auschwitz, they did prosecute the Krupp corporation leaders for that.
Of course.
And so it's not like there's not precedent for going after corporations. It's not like corporations haven't been involved in atrocities. So you're now working on a sequel to your book. Can you tell us a little bit about that?
Well, I call it preliminarily my second life, but I was told by a number of publishers in Europe that they heard from their readers who said, well, your Lucky Child book, your first book, you stopped writing it when you arrived in the U.S. at the age of 17. And what happened to him afterwards? And particularly in Europe, they wanted to know what happened to this kid after all those years. And so they asked me whether I would be interested in doing it. And of course, I couldn't resist. It's not as easy to write, because the first book was easy to write. It just flowed out of me. This one has to, first of all, I've gotten a little more mature about what I can say and what I cannot say. But it's just much harder. And of course, all these years I've spent in the U.S. But I'm writing it in a way as dealing with episodes of my life, because I've come to the conclusion that if I began at the beginning of, say, when I arrived in New York, I would have to have about at least 120 years of my life.
It'd be like Winston Churchill's many volumes set. We only have a couple of seconds left before our station break, but can you tell us what you think the theme of your life has been?
Well, the title of my first book was A Lucky Child. And I'm often asked by people who say that luck is not really the way to deal with it. It was luck. Because if people speak of divine intervention and things like this, that would be such an arrogant notion. And I felt I survived out of luck, because so many, 1.5 million Jewish children did not survive. So that's the theme, and the theme is to prevent that from happening to other children.
Judge Buergenthal, I think all of us who have had the privilege of knowing you feel that we are the lucky ones, and that you have given so much to the world of human rights law.
Thank you.
It's time for a short station break. When we return, we will dive more deeply into the case of Jesner versus Arab Bank with our panel of experts. We'll be back in just a moment. Welcome back to Talking Foreign Policy, brought to you by Case Western Reserve University and WCPN 90.3 ideastream. I'm Michael Scharf, the Dean of Case and Reserve University School of Law. We're talking today about whether corporations should be liable for human rights abuses committed abroad. In this segment, we're going to bring some local human rights experts into conversation. We're being joined today by Milena Sterio, the Associate Dean of Cleveland Marshall College of Law, who is a regular guest on our show. It's great to have you back.
It's a pleasure to be here.
And we also have with us Case Western Reserve law professor Avidan, who is director of the school's Institute for Global Security Law and Policy and runs the school's Human Rights Clinic.
It's great to be here.
Avi is sitting where Judge Buergenthal was just. We are also joining from Case Western Reserve Professor Tim Webster, who teaches human rights law and has published cutting-edge research in this area.
Thank you, Michael.
And then finally, we have Carsten Stahn, who is our special guest from Europe. He is an expert in international criminal law. He's the director of the Grotius Center and a professor at Leiden University. Carsten, thanks for coming all the way in from The Hague.
Thank you. Wonderful to be here, Mike.
So I understand there's a big human rights case about to be argued at the U.S. Supreme Court. Let's start with some background. And Milena, can you start by telling us what this case is all about?
Sure. So the case is called Jesner versus Arab Bank. The plaintiffs are a group of victims of terrorist attacks that took place between 1995 and 2005 in Israel, the West Bank, and Gaza. The defendant, the bank, is a bank located in Jordan, which has branches throughout the world. It has over 500 branches throughout the world. And the plaintiffs allege that the bank essentially supported terrorism by maintaining accounts for known terrorists, by accepting donations that the bank knew would be used to fund terrorism, and by distributing millions of dollars of payments to families of suicide bombers. Now, the bank says none of this is true. It says basically, I'm a bank, I'm a normal bank, I don't engage in or I don't support terrorism, and the bank basically describes itself as an active and leading partner in the socioeconomic development in the Middle East.
So the victims are from what country?
The victims are mostly from Israel, from the Middle East.
And the bank's from what country?
The bank is based in Jordan, although it has branches throughout the world, but based in Jordan.
And this case isn't before an international court. It's right here in the United States. What is it about U.S. law that allows foreigners to sue other foreigners for human rights violations in U.S. court?
Sure. So the plaintiffs are actually using a U.S. federal statute called the Alien Tort Claims Act. The Alien Tort Claims Act is a federal law that gives U.S. federal courts jurisdiction over civil actions by aliens for torts committed in violation of the law of nations or a treaty of the United States. And so here we have plaintiffs who are aliens, foreign citizens, who are suing another alien, a bank located in Jordan, for a tort committed in violation of international law, which would be support of terrorism.
Well, this seems like a very modern statute. When was it adopted?
So the statute was adopted actually back in 1789 and was part of the original Judiciary Act, which essentially set up our federal courts. It basically sat dormant until 1980, so for almost 200 years, nobody had ever used it. And then in 1980, there's this other case called Filartiga, where two plaintiffs who were from Paraguay decided to essentially resurrect this federal statute and use it to bring a lawsuit against another Paraguayan citizen for torture. And in that case, the United States appellate court, the Second Circuit, held that, yes, this statute could be used, the Alien Tort Statute could be used for this kind of a lawsuit by a foreign plaintiff, an alien, if the tort is something that is basically a violation of international law.
Now, Tim Webster, you teach human rights law. You teach this area, the Alien Tort Claims Act litigation area. It doesn't seem like the U.S. Supreme Court likes this Tort Claims Act very much. In two recent decisions, the Sosa case and the Kiabel case, it's greatly cut back on the usefulness of this statute. Can you tell us about those cases?
Sure, yeah. So there's two cases, and again, our Supreme Court is there to help clarify what federal statutes mean and what they can do. The first case is from 2004. It's called Sosa. The second case is a more recent one called Kiabel from 2013. Let me go back to Sosa for a minute. What Sosa did, and this gets to what Professor Sterio was just talking about, Sosa says that this law, this Alien Tort Claims Act, is jurisdictional. And what that means for people who are not lawyers is that this opens up U.S. federal courts to lawsuits from anywhere around the world. So it doesn't talk about the cause of action. It doesn't tell us what the remedy is. It says only that U.S. federal courts can hear these kinds of actions. The second piece of Sosa suggests that the kinds of actions, the kinds of torts that are permissible in the United States have to be very specific. And they say, if we go back and look at the 1789 law, there needs to be a high degree of specificity. And the Supreme Court said in 2004 that it has to be something along the lines of piracy.
Torture.
Torture would be another one. That wasn't one they actually mentioned. But they said, look, these needs to be very specific norms we're talking about. We're not letting everybody in here. These norms have to have been articulated clearly and specifically in order for our federal courts to be open for these foreign plaintiffs. So that's the Sosa decision. But again, you can see by requiring this specificity how other kinds of acts would be excluded, other kinds of
in fact,
lawsuits.
Human rights violations that are short of torture or even terrorism, it's not clear
Absolutely.
that they would think that there's a universal definition of terrorism like
Absolutely
there is
right.
for piracy, for example.
Absolutely right.
Okay.
Yeah. So again, the Supreme Court said the norms that we're going to allow these courts to proceed under have to be very specific and have to be clearly defined. There has to be a widely accepted definition.
Okay, then what about the Kiobel case?
So Kiobel comes around, 9 years later, and you set this up quite nicely with Professor Sterio. You said, look, in the Jesner case, we have a foreign plaintiff suing a foreign defendant for actions that took place abroad. And so the concern here is, well, look, why are we here in the United States? Why are we having these lawsuits where there's very little discernible U.S. interest at all? And the Supreme Court in Kiobel said, well, look, we are going to place what they call a presumption against extraterritorial application. That's a mouthful. What that means is, what's the U.S.'s interest in having our courts hear this case? And so the language there said, look, there is a presumption that we should not hear these cases, but that presumption can be overcome. We will allow these cases if the plaintiff can show that the action somehow touches and concerns. That's the magical language. Does this case touch and concern the United States? Now, what does touch and concern mean? No one is exactly sure. It's somewhat vague language. In one of the concurring opinions offered by Justice Breyer, he said, touch and concern means the following. It means A, the conduct took place on U.S. soil. It means B, the defendant is an American, or, and this is the arguably or possibly the catch-all, the defendant's conduct affects an important national interest of the United States. Right? So the first two are quite clear, quite specific. The third one says, does this affect an important national interest of the United States? And you could argue that preventing terrorism or preventing the financing of terrorism, which is what Jesner is about, represents an important U.S. national interest. But that is the hurdle. That is the obstacle that Jesner needs to surmount in order to continue.
And the Arab Bank in this case also has branch offices in New York in the United States. It does business in the United States. Maybe some of the terrorist financing in this case went through U.S. banks.
Absolutely,
So there was
yes.
a connection.
If we can show that, then there would be it would touch and concern the United States.
All right. So the issue that the Supreme Court wanted to use this case for is based on the defendant's argument that corporations cannot be liable under the Alien Tort Claims Act because only governments can violate international law. And Milena, Sterio told us that the statute only allows the courts to entertain suits for violations of international law. Now, Judge Buergenthal, who was here in our earlier segment, he said, that's old think. What do you think? Is there anything to this argument?
Right. So to take that argument on frontally, you and I were talking about piracy, and even in 1789, piracy was a violation of international law. Now, piracy back then and even now is generally not committed by governments, right? It's human beings and arguably even groups of human beings, arguably even corporations that participate in piracy. There are opinions from the 1790s. There were opinions from the early 20th century that say, particularly with regard to the Alien Tort Claims Act, that the Attorney General of the United States penned that said corporations can be liable. Right. So even though we haven't seen a lot of cases, and of course there are Alien Tort Claims Act that have held corporations can be liable, this idea that corporations can't be liable and that only governments can be liable for international law has been, if not debunked, at least challenged for a couple of centuries now.
Well, we'll see where the Supreme Court goes on this. Professor Avidan Cover, you teach human rights clinic. You litigate these kinds of cases. You're a national security law expert. From a human rights perspective, what do you think is at stake in this case? Big picture, what's this precedent likely to do?
Yeah, well, to use a certain international leader's terminology, this is a huge case. I think what's at stake for human rights is that the United States is in step with, I think, the developing trends in the world on human rights. There's a general growing recognition that corporations should be held liable for human rights violations. We've seen it. A number of the United States allies, like the United Kingdom and the Netherlands, have recognized genocide and such other crimes as there being corporate liability, even in their domestic statutes. And so I think the growing consensus is that, and I think great support for that. Now, it's interesting. The issue that the court accepted as it's formally presented is whether corporations are categorically exempt from liability under the Alien Tort Statute. And that language, a lot of people, a lot of court critics suggest and infer from that is a favorable position in terms of finding that there will be, at least at some level, corporate liability. That is just the way that that's phrased is just so limiting that the court is not going to sort of buy into that kind of prohibition. But it's interesting what Tim was focusing on, that second issue. One question is whether the court may be able to yet again kick the can down the road and avoid that question, potentially by simply finding that the matter is basically extraterritorial, right? That there's no nexus. And so perhaps decide that issue and evade, at least for the time being, whether indeed corporations can be held liable.
So Professor Webster, Tim, was saying that there's a national security interest. You're saying there's this huge human rights interest. But against that is the business law interests, the business community. And often courts are very concerned about that. Milena, Sterio, the U.S. Chamber of Commerce and other business groups have filed briefs with the defendants. What's their argument?
Sure. So obviously from the business side, from the corporate side, the fact that corporations could potentially be liable for human rights abuses is not a good thing. So the U.S. Chamber of Commerce and other business groups have filed briefs with the Supreme Court arguing against extending the Alien Tort Statute to cover corporate liability. According to these briefs, some of the arguments that have been raised in these briefs is that the Alien Tort Statute lawsuits against corporations have run rampant in recent decades, that there have been, dozens, if not hundreds of ATS cases against U.S. and foreign corporations that do business in 24 industry sectors arising in corporate activity throughout the world, and how essentially holding corporations liable is not a good thing because it will stifle their business activity. It will, harm everyone's interest in a sense. So they're really squarely against this.
Avi, did you meet Justice Gorsuch when he came to Case Western a year ago?
Yes, very briefly.
You did? Okay,
yeah.
So the newest justice of the Supreme
Right.
Court, a conservative justice, nominated by a Republican president, Donald Trump, confirmed by a Republican-controlled Senate, is Neil Gorsuch. And what do you think his addition to the court is likely to do to the outcome of what might be a very close case?
Right. It's very interesting. Justice Gorsuch only joined the court 4 days, or he was confirmed only a few days after cert was granted in this matter. So he didn't play any role in deciding whether to take this case or not. He is a justice who he had been part of the 10th Circuit Hobby Lobby decision, holding that corporations have perhaps certain religious liberty interests. So he may be viewed as someone who is certainly very sympathetic to corporations. Certainly plenty of his jurisprudence while he was on the 10th Circuit as an appellate judge suggests that he would be sympathetic to the corporation's position. That said, he also served in government, and the federal government's position on this, while acknowledging that corporations can be and even should be held liable under the Alien Tort Statute, is of the view that the extraterritoriality decision should be determined first, and that, in fact, national security implications of perhaps improvidently deciding this case and affecting the relationship with Jordan in particular could adversely affect national security concerns. And so I could certainly see Justice Gorsuch, who certainly holds himself to be a strict constructionist, reading the statute as narrowly as possible, reading the court's role as narrowly as possible, might opt for that second route, which is to say that the court say that these issues there is no nexus, and so again, to kick that can down the road.
Now, for the other justices, they sort of painted themselves into a corner with the Citizens United case. Citizens United, as the listeners might recall, is this case that President Obama said was the worst decision the Supreme Court ever had. It's the case that said that corporations are people for purposes of the First Amendment and therefore have a right to contribute to political campaigns and cannot be constrained by the federal legislation. So if corporations are people for purposes of giving a lot of money to political campaigns, Milena, Sterio, or Avi, why can't they be people for purposes of human rights violations?
I actually think that the Supreme Court in this case, in Jesner, will actually decide that corporations can be liable. I think it will be a very, very narrow holding. I think Justice Roberts will write an opinion where he will, specify a very narrow set of circumstances under which corporations can be held liable for human rights violations. And I think that would be in line with the Citizens United case, because if corporations have free speech rights, then certainly they can commit human rights violations. And I think it would be very unpopular for the Supreme Court to rule that corporations are categorically exempt from this line of lawsuits.
Carsten Stahn, you've been very patient over there from the Netherlands, and we're going to bring you into the next segment. But are you over in Europe following this case? Is this something that is on the radar of Europeans?
The issue is very much on the radar of Europeans because there have been a couple of cases as well in the European context where cases have been brought. For instance, there have been proceedings concerning Mercedes-Benz for its involvement in enforced disappearance during the Argentinian dictatorship. So it's an issue which also, because of the diversity of different domestic systems that we have, raises a lot of interest.
All right. So with the few seconds we have left in this segment, Avi Cover, how do you think the case is going to be decided?
I kind of like Milena's take on it. I mean, I think that I can't imagine it will be an unequivocal embrace of corporate liability under ATS, but I think they'll try and limit it as much as they can.
So 5-4 in favor of the plaintiffs.
Yeah, with a certain narrow exception.
Milena, is that?
I absolutely agree, because also the way that the Supreme Court has framed the issue, which is essentially taking the plaintiff's way of framing the issue, that really indicates that the Supreme Court is more likely to side with the plaintiffs.
And Professor Webster, you were saying they might dodge the issue altogether. What do you think?
I would agree with my co-panelists here, but I would just underline that they will take the narrowest possible ruling that they can.
Which might be to say that since the bank isn't an American bank and there's not enough of a connection, that the case doesn't go forward, right?
Possibly, or they can say this does implicate a major national interest, that of preventing the financing of terrorism. So we do think, again, citing Justice Breyer's concurrence, that this does affect U.S. national interests in a significant and robust manner.
Well, everybody out there who's following the Supreme Court this term, hold on to your seatbelts because it's going to be a bumpy ride, and this is just one of the first cases that will be decided. So I hope this discussion has shed some light on the importance and likely outcome of the Jesner and Arab Bank case. It's going to be time for another break in just a few seconds. When we return, we'll talk about the international effort to criminally prosecute corporations for human rights violations. Back in a moment. This is Michael Scharf, and we're back with Talking Foreign Policy. I'm joined today by some of the world's foremost international law experts, and we've been talking about liability of corporations for human rights abuses. In this final segment, we'll look at the International Criminal Court's new focus on prosecuting crimes committed by corporations. With us in the studio, we have Professor Tim Webster from Case Western, Associate Dean Milena Sterio from Cleveland Marshall, the Director of the National Security Law Center at Case Avi Cover, and all the way from The Hague, the Netherlands, we have Carsten Stahn, a professor at Leiden University. Let's begin with Carsten. And you are really one of the foremost experts about the International Criminal Court. And this is not the World Court that Judge Buergenthal sat on. This is the court that prosecutes individuals for the worst crimes known to humankind. It sits in The Hague, where you're located. And you even run, and I assist you, with an International Criminal Court moot court competition where students from all over the world participate and learn about this court. So can you give the listeners some background about how the ICC works and what kinds of cases it focuses on?
Thank you, Michael. The ICC is the first global court which tries international crimes against humanity, genocide, war crimes, and potentially in the future also aggression. Its jurisdiction is very limited. So first of all, the court only tries individuals. That means it doesn't have corporate criminal responsibility as such. Second, the court can only try nationals of states parties or crimes which have been committed on the territory of states parties. A couple of states, like the United States, like Russia, like China, are not party to the statute, and recently African states have like Burundi or South Africa, have indicated their intention to even withdraw from the statute. So these are issues that the court has to struggle with. In addition, it's complementary to domestic jurisdiction. That means whenever there is a good domestic case, the ICC will not step in. In light of this, the role of the court in this will remain limited. But the few cases that the ICC does are, of course, hugely important in terms of the impact that they have. It's the shadow, it's the message that the court sends that is really important.
But you said that when they drafted the court statute, they purposely left out liability for juridical persons, which means corporations. Only natural persons, which are people, can be prosecuted by the court. In your opinion, does that create a gap in international criminal law that corporations can exploit?
Indeed. The famous, it goes back obviously to the famous Nuremberg precedent, which said that crimes are committed by men, not by abstract entities. And since then, France proposed in 1998 that the ICC should have jurisdiction over corporations precisely in order to increase the rights of victims, also to have access basically to compensation through criminal proceedings. This obviously didn't get enough consensus because our domestic systems still differ on how to treat corporations.
I was talking briefly with Judge Buergenthal, the first segment, about the Krupp Corporation, which was prosecuted at Nuremberg when they prosecuted Krupp Jr. And there's an interesting story behind that. Krupp Sr., the real president, the head of the corporation, was too ill and frail to be prosecuted. So they just grabbed his son because he had the same last name. And do you remember what happened, what the result of that trial was?
He was convicted, yes.
Well, no, Krupp was acquitted. He was one of the three that were acquitted at the Nuremberg trial. And the reason for that, and what most experts say, is that the father was guilty, but he was too frail. The son was the wrong person, but really they should have gone after the corporation.
Indeed.
Right. And so that's the problem, that if you don't have the right defendant, corporations who are made up of a collective of board members and officers can get away with heinous things. But Carsten, even after the Krupp Corporation case, there have been a lot of cases against corporate officers in international tribunals. I know in the Rwanda tribunal, they went after the president of a tea company that had facilitated genocide using his employees, and also the president of a radio program that had broadcast all sorts of incitement to genocide broadcasts. So there's nothing really new about going after corporations, is there?
There's a distinction between, right, to what extent can we hold corporate agents then accountable for what the corporation as such has done. And here we've seen, I think, recent developments, also in the context of both the International Criminal Court as well as in the African context, to try to bridge the gap and to increase business accountability. The ICC prosecutor wanted to bring cases against corporations at the beginning in relation to the situation in the Democratic Republic of Congo. For instance, diamond trade is the obvious example. But the court obviously has to be very selective in its focus. So only recently did the problem gain attention, and the ICC prosecutor developed a new policy paper in which they then identified some of the types of violations that the ICC might look into, even if it can't look into the issue of corporate criminal responsibility as such.
So what were those?
And these are the issues, for instance, illegal exploitation of resources, land grabbing, for instance, or destruction of the environment. There has been a communication brought against Chevron, for instance, for intoxicating the environment in Ecuador, basically through its activities. So these are the potential issues that might come before the ICC.
So in those cases, what you think will happen is the ICC will investigate the corporations, but ultimately they won't prosecute the corporations as such. They'll go after some officer who they believe is most responsible.
Indeed, this is probably what will happen. They will try to trace the patterns of crimes. They might identify some of the violations. Some of the cases might not even go to trial, but it might be even the fact that the ICC looks into something, that it identifies something as a violation, which might have a tremendous impact on domestic states, on corporate policies, because of course if you're on the headlines with the ICC, if what you have done is basically made transparent through ICC proceedings, that in itself might have a very important effect.
You know, there are a lot of corporations that were involved in the Nazi Holocaust atrocities that still exist today under different names, but you can trace their ownership all the way back. Would you say that it's a failure then just to prosecute an individual if the corporation can continue to exist? Because when you prosecute individuals for individual crimes, you lock them up sometimes for life if it's genocide, and then they can't commit the crimes anymore. But if you only take an officer out of a corporation and the corporation continues to exist, what's the deterrent?
Absolutely. You only capture basically, I think, a fraction of the corporate injustice. And I think the big tragedy is that in most of these cases, particularly in fragile environments, if we try individuals, the profit that companies gained from these investments, from their activities, basically they're not taken into account in the equation. That means that victims often stay without remedies. And I think that's the big tragedy that we face. And this is why some more recent instruments, for instance, like the Malabo Protocol established by the African Union, now establish corporate criminal responsibility precisely in order to close this gap.
But it's not likely that they're going to amend the ICC statute. So maybe you can prosecute people in Africa, maybe you can prosecute them domestically in Europe or even in the United States, but not before the International Criminal Court. The corporation is going to be free and clear, but its officers may not be. Now, the prosecutor of the ICC, the International Criminal Court, wants to go after the corporations, even though it's only the officers that they can get a hold of. Avi, Milena, and Tim, do you think that's a good idea? Is the new priority that she has announced on going after corporations the right thing for the International Criminal Court to be focusing on?
I think it's a critical piece of what you should be focusing on. As Carsten identified, issues of mineral extraction, land appropriation, these sorts of things. That's being done at the hands of corporations, and whatever kinds of accountability, whatever retribution, deterrence can be achieved through those investigations, through the notoriety that is achieved. I think those are a critical piece of our legal system.
Milena?
And I think it is important because as Carsten and Avi already pointed out, there are cases where going after the corporate officers is really, really difficult, because if you're trying to impose individual criminal responsibility on some of the corporate officers, you have to show, for example, that they had the requisite criminal intent to commit specific acts, that they actually committed the acts or somehow aided and abetted in the commission of the acts, and that's sometimes very, very difficult to do. So going after the officers is sometimes going to be impossible, despite the fact that corporations might be committing pretty horrific violations of human rights and other crimes. So I think this will, going after corporations is important to close that gap.
So, Tim, do you agree if you have cases about genocide and cases about corporate damage to the environment, is there equality of those two? Or
I'm going to maybe take a slightly different approach than the co-panelists here. And again, thinking about the ICC as an institution and as a institution that's trying to make sure that its legitimacy is respected around the world. Professor Stahn mentioned that a couple of countries in Africa have signaled their intention to withdraw. We know that China, Russia, the United States, and numerous other Asian countries have not join the ICC. And so here I would say actually we need to look at the Rome Statute. And, we had this conversation back in 1998. The French government said, why can't we have criminal corporate liability? And the discussion said, no, we can't have that. So I don't fancy myself a strict constructionist, but I think when we have an institution that is sort of fighting for its legitimacy, I think it may overreach to then investigate corporate criminal liability when it has not been specifically authorized to take that within its mandate.
You don't agree, Milena?
No, I would just mention this, that the U.S. Ambassador for War Crimes, David Sheffer, who was present at the Rome Statute negotiations, he has written and spoken about this. And he basically says that one of the reasons that this issue of corporate responsibility was dropped, wasn't adopted as part of the Rome Statute, was that the consensus at the time was that most national laws at the time did not have provisions for criminal liability for corporations, and that most national laws have evolved since then and now do. So that would be a counter argument to that.
Well,
Sir rebuttal.
Do you want to go back?
Some countries have now imposed criminal corporate liability. by far, I believe, the minority.
Yeah.
So if we can say 120 states do it,
Sure.
yes. But if we just say, well, France, Netherlands, and Germany have done it, and therefore everyone does it, I think that's a bit of a stretch.
Well, so the thing about interpreting a statute, it's like interpreting the U.S. Constitution. Are we going to be strict constructionists, or are we going to evolve with the times? Going back to Carsten, the Special Tribunal for Lebanon, which is another one of these international tribunals, had this precedent-setting decision on contempt. Can you tell us about that and why it might be relevant to the question that we're talking about in interpreting the ICC statute?
Indeed, this was a very special decision of the Special Tribunal for Lebanon, who had to decide whether contempt of court could be exercised against a media company. And it's not in the statute in itself. I mean, it just uses the term persons. It doesn't specify whether it's natural or legal persons. And it then found that actually corporate criminal responsibility is a general principle of law, which is, of course, a very far-reaching statement if we look at it. This decision has been disputed. Some scholars have said this is really imagination and it's wishful thinking, but we don't have enough evidence for it. Others have endorsed it. So I don't think, first of all, it's only related to contempt powers, not to international crimes. And secondly, it was influenced by the fact that Lebanon has criminal responsibility in its own domestic code. So that means I think we shouldn't overstretch the decision. But it might have an important effect in signaling, like the ICC, through a decision you might basically trigger domestic reform, you might make NGOs think differently about the issue, and it's about the basically the shadow of the law where this decision might be important.
Now, assuming that the ICC prosecutor is going to be going against corporate officers for corporate actions, let's take a specific concrete example and see how that might play out. Milena, let's talk about human trafficking. So what's that crime? What does it involve? Could it be a crime against humanity?
So there's actually a definition of trafficking in the so-called Palermo Protocol, which is a protocol adopted as a supplementary protocol to the UN Convention Against Transnational Organized Crime. And the Palermo Protocol defines trafficking as persons as the recruitment, transportation, transfer, harboring, or receipt of persons by means of the threat or use of force or other forms of coercion. Now, when it comes to prosecuting trafficking, arguably you could prosecute it as part of Article 7 of the Rome Statute of the ICC, which is the article on crimes against humanity. And that article actually has a so-called trafficking clause in Article 7.1c, which basically explicitly refers to trafficking in persons and in particular women and children. Now, trafficking has been investigated and essentially prosecuted as part of crimes of sexual violence within the Yugoslavia and the Rwanda tribunals, and it could be potentially prosecuted in the ICC. However, it would have to, if it's prosecuted as a crime against humanity, it would have to take place on a widespread and systematic scale as an attack against the civilian population. And obviously, anytime we talk about the ICC, as Carsten already identified, there are significant jurisdictional and admissibility hurdles to any ICC prosecution.
So now here's the thing about corporations. They're unlikely to be involved in actually, prostitution per se. Or slave labor per se. Well, some of them might be, but they are more frequently going to be facilitating the trafficking. So let's talk to Tim Webster about a situation where a corporation creates a website that allows traffickers to advertise, let's say, the availability of child prostitutes. Could the corporation and its officers be liable for the actual trafficking simply by allowing them to advertise on their website?
And we're talking about here in the United States?
Yeah, generally.
Okay.
Yeah.
So, I think the aiding and abetting decisions under Alien Tort have all been about corporations aiding and abetting governments. So this would be distinct from that. Here you're talking about one corporation, helping another one set up a website. So that may pose some problems. On the other hand, as we talked about with Kiobel, if we can say that human trafficking is first of all, a part of international law, there is sufficiently crystallized customary international law, and it affects an important U.S. national interest, and I think most of us would agree that human trafficking does represent an important U.S. national interest, then yes, I could certainly see at least jurisdiction being allowed and the case allowing to move forward. But again, I haven't actually seen that case unfold in the U.S. just yet.
So that's the website type of case. Tim, let's take a different scenario. What if a corporation purchases goods from a group that is involved in human trafficking? could the corporation be criminally liable if it had knowledge that it was getting those goods and they were being exploited by these laborers? So I'm thinking, for example, of corporations that purchase shrimp from the shrimp peeling shed operators in Thailand. I don't know if you're familiar with this case, it's pretty horrific, but these people are paid almost nothing. They are migrant workers. They're almost enslaved there. And then other companies around the world, including many of our producers of shrimp, are just buying their shrimp, with full knowledge of what's going on. Could those companies be engaged and prosecuted for the human trafficking, for their involvement, for aiding and abetting?
Yeah, that's a tough question. I would say, we need to, if we're talking about criminal prosecution, we need to make sure that we have a clear and clear statute on the book that a federal prosecutor can hang his hat on. I haven't heard of that particular case, and I suspect the reason is because federal prosecutors have enough to deal with when they're trying to handle U.S. domestic crimes, and so they may feel that their resources are best targeted or best spent targeting issues that are of more central concern to the United States. Now, that's not to say it's impossible. Maybe if this does become a major issue, it does attract a lot of media attention. It could be, but I can't see a state or a federal prosecutor using those resources to affect Thai shrimp production as opposed to human trafficking here in Ohio.
That's going to have to be the last word as we're running out of time. I think we learned a lot about the civil and criminal prospects for liability of corporations. Judge Buergenthal, Dean Sterio, professors Cover and Webster, and Carsten Stahn, thank you all for providing your insights on liability of corporations for human rights abuses. I'm Michael Scharf. You've been listening to Talking Foreign Policy.
Talking Foreign Policy is a production of Case Western Reserve University and is produced in partnership with 90.3 FM WCPN ideastream. Questions and comments about the topics discussed on this show, or to suggest future topics, go to talkingforeignpolicy@case.edu. That's Talking Foreign Policy, all one word, @case.edu.